I want to talk a little bit about the changes that will come with the passage of this legislation. The first, you know, the two biggest changes that will come in what will be the baseline for all custody, and that will be equal legal and physical custody as the starting point. Now, that does not mean that everybody will have equal legal and physical custody if it is not right for their family, but it means this is where they start. And a judge, unless you have been found unfit or harmful to a child, they cannot give you anything different. Now, the other caveat that goes with this is the fact that we're going to change the evidentiary standard. As it is now, what we have is we work off of affidavits. And while they are sworn statements, they can quite often contain lies and misnomers. Unfortunately, now, under current statute, the courts believe these. And then if something is said about one party or the other, and the courts believe it, then you're stuck. You have to, as the opposing person or the one that is said about, you have to fight your way out of that hole. I mean, I use an example a lot of times when I'm speaking on this of writing an affidavit and saying that my soon-to-be ex is purple with pink polka dots. Now, it may be pasty white, but the courts will believe this, and I can say in my affidavit that, oh, a person that's purple with pink polka dots cannot possibly be, good to be around a child because they're just, that's just not right. Well, we can't have that. Okay, this opens up a lot of different things. When we change this evidentiary standard to clear and convincing evidence, which is the highest standard that you can have in a civil court, which is what domestic relations and the family court system is. It is civil court. You now take that let's tell a lie to gain an advantage out of the picture. By changing to this standard, what we do is we send a clear message. You're not going to tell lies. You're not going to tell lies to try and get an advantage. And if you say something about somebody, you darn well better have the proof to back yourself up. Now, that changes a lot of things because it takes out the false allegations, which have bound and tied up the courts for, in many cases, for years. That alone right there will streamline the process tremendously because now you don't have to go through the additional burden of trying to unbury yourself once you've been buried by the lies. You take the false allegations out, you can move things through very quickly. By having a set standard also, and a directive issued to the court that you're going to start at equal legal and physical custody, we know that's the default. It may not be right for every family, but what happens is this will encourage families to come up with a plan that fits the needs of their family. As it is now under Ohio law, if you allow this to a judge, it becomes what I've used as an example of you walking into your neighbor's house 3 or 4 houses down the street who you do not know and saying, this is how you're going to raise your family. Now that none of us would want to do. None of us do that. But what we have done is we have let the courts do that in the state of Ohio. Cannot have that anymore. That's what set us behind. That's what's caused a lot of the problems, because with this old standard of thinking in the old way against the modern family, and the current laws do not match up. So what we end up with is fit parents consistently being removed from the lives of their children. That can't happen anymore. This bill will correct that. I think one of the unintended consequences that will happen out of this, because as it is now, if you go into divorce, you can gain an advantage. You won't have that advantage. If parents know that they're not going to have an advantage by getting in there, they're going to be more likely to work out the problems in their relationships. So I think in the long run, we will probably see a reduction in the divorce rate in the state, just as one more thing, along with all the other benefits to children. So those are the two key points that we're going to start with. And we need to be conscious that these will be the major issues. And quite frankly, both of these things have been things that, in talking to legislators, they've been all in favor of, because they know that we have a mess. And it is a mess based on the broad discretion that is given to these judges. I've used an example, and I used an example back a dozen years ago when I testified on HB 232, that the judges in family court, domestic relations court, have such broad discretion that if they tell your child, they write an order that tells your child that they are to play in the middle of the freeway during rush hour, that is what you're stuck doing, and you darn well have to go by that. That's wrong. Nobody should have that much power over somebody else. Judges say, well, we'll lose our discretion in this. Well, it's been their discretion that has hurt so many children and so many families. We're going to take that away. We're going to make them practice real law. Now, it doesn't end their discretion, but what it does is it gives them a strict guidance in how their discretion is to be used. So that's the two basic differences between current law and what is coming with the passage of these bills. We want to thank you for tuning in, and I will continue on with the next series.